We can also quickly deal with number 31, which is a motion to exclude the statements of officers Tou and Lane. And for points of clarification, officers Tou and Lane gave tape-recorded voluntary statements to the BCA and in connection with the FBI, counseled by attorneys. They signed criminal investigation warnings, understanding that their statements can't be used or could be used against them. That's all I'm talking about. I'm not, again, talking about what's on the body camera footage or those statements. I believe, based on the submissions the state has already agreed to, that they agree that that's testimonial evidence, that I would not have the ability to cross-examine those other witnesses. I confirmed with each of the attorneys last night that they are not permitting their clients to testify in this trial. I would have no ability to cross-examine those particular statements. Anything else, again, I think it's fair game.
Is the state intending on offering any of that? Mr. Frank?
We would not offer them chief, but there is the issue of expert reliance.
There is no lack of cooperation by the Minneapolis Police Department in this case, and I think that any reference to that would simply be to try to inflame the passions of the jury or create some sort of a conspiracy that the officers are just trying to cover themselves or protect one of their own.
I think it could be argued, we cannot say entirely, but by and large, for the most part, we do not intend, for instance, an opening statement to make statements about a blue line or something as represented in this motion. However, we cannot be, it's our position, prohibited at this point from raising bias if that becomes apparent during testimony at trial. And that is possible. And so I think this motion is in that sense then premature because it should be determined on a witness by witness basis